Very, very bad news for the Bureau of Alcohol, Tobacco, Firearms, and Explosives, what really should be a convenience store name and not a government agency. If you read carefully the Loper Bright decision that said the Chevron Doctrine is gone bye-bye, thank God, great news for freedom, there's some really interesting language that suggests that some of the games that the ATF has been playing with their redefinition of words is not going to sit well with the Supreme Court. Wait till you see what I've uncovered in Loper Bright and what it means directly, specifically to the ATF. Stay tuned. You're not going to want to miss this one. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed, What the 10/7 Terrorist Attacks by Hamas on the Israelis teach Americans, that's teach us, about the right to bear arms. Check it out on Amazon, and if you've already bought a copy, thank you, and I encourage you to leave a review, whether you like it or not, on Amazon, so other people can get a sense of what the book is about. All right, folks, so here's the story. We've already covered in detail about how the United States Supreme Court in the Loper Bright decision wiped out the Chevron Doctrine, which some people have called the divine right of deference, where courts had to defer for the last several decades to an administrative agency's interpretation of a particular law. Even if the court might disagree with that interpretation, they were supposed to defer to the administrative agencies or the regulators or the unelected bureaucrats' interpretation of that law because they were the subject matter experts, the intellectual giants in the space. Well, that is gone because the Loper Bright case by the U.S. Supreme Court in a 6-3 decision took the Chevron Doctrine and threw it in the trash bin of history, just as I predicted, just as you knew about this many, many, many months ago, way back last year, in fact. Now, with that said, I took another more careful look at some of the language that the U.S. Supreme Court used in Loper Bright, and I'm going to bring you some of these tidbits and nuggets over the next several weeks about what I've uncovered in the various Supreme Court cases that will have specific applications to Second Amendment and gun-related issues going forward in the courts. And I found repeatedly mentioned something quite fascinating that is not going to make the ATF happy at all. There's discussions in this case about the importance of contemporary or contemporaneous information and interpretations by administrative agencies of relevant statutes. Did you hear what I just said? I'm going to show you what it means in a second. The Loper Bright decision by the Supreme Court emphasizes the importance of, and perhaps the possible deference to some degree, to contemporaneous interpretations by regulatory agencies of federal statutes that govern a particular topic. What does that mean in the context of the ATF and gun rights? What it means is that the Supreme Court says that the best evidence often of what a federal statute means is how did the regulators, how did the bureaucrats interpret that statute contemporaneously with the enactment of that statute. Now, why is this important for the ATF and our Second Amendment rights? What year was the NFA enacted? You know the answer. It was enacted in the decade of the 1930s. And what year was the Gun Control Act first enacted? You know that. It was enacted in the 1960s, specifically the year of our Lord, 1968. So let me ask you this. If the ATF has interpreted certain words or meanings one way back, let's say in the 1930s or in the 1960s, and then miraculously, after the election of, let's say, a president like Joe Biden in 2020, taken office in 2021. And then out of the blue, that administrative agency like the ATF decided to change all of its interpretations and understandings of what the statute meant. What does the Supreme Court say about that kind of conduct by an agency? It basically says that that is evidence that the newfangled approach and interpretation of the meaning of those words is likely BS. Stupid. Inconsistent with the meaning of the statute. Now, why is this important? Well, we know why it's important. Because whether you look at the ATF's original definitions of AR-style pistols with braces, pistol braces, whether you look at the original interpretation of the statute as to what a firearm is, which includes, among other things, a frame or receiver, and not parts of frames or receivers, and what engaged in the business of firearm sales means, or the commerce of firearms. And back, although this is not relevant for now because it's already been won, what a bump stock is and whether or not it's a machine gun. If you look at all these instances, you will see that the initial interpretations that an AR-style pistol with a pistol brace is not a short barrel rifle under the National Firearms Act. You will look to see that the ATF's initial interpretation of what a frame or receiver is and what a firearm is not a part of or a component of or something that can be converted into a frame or receiver. That's not how they initially interpreted. And the definition of engaged in business the same way. Same with the bump stocks. The point is that I'm going to give you language out of the Loper Bright case that clearly indicates that to the extent the courts are interested in trying to understand what is the original meaning and understanding of the enactors of the language of a statute enacted, let's say in the 1930s or in the 1960s, they're going to look contemporaneously with the enactment of those laws, possibly to see what the regulators interpreted those laws to mean. Now, that doesn't mean the court said in Loper Bright, that doesn't mean they're going to absolutely defer and rely on what the ATF interpreted a law to mean after it was enacted in the 60s, or the relevant agency interpreted the National Firearms Act, what it interpreted to mean in the 1930s. They're saying, though, that it might be relevant evidence for a court to consider. Now, this is devastating, in my view, to simply every single thing that the Biden administration has done by executive fiat, by simply waving its magic wand and changing its meanings and changing its interpretations with political wins. Because whatever they've just done is going to be entirely inconsistent with the original understanding and the original regulatory understandings of what is a pistol brace, what is an AR-style firearm with a pistol brace? Is it a short barrel rifle or not? What is a frame or receiver? If it's simply a part of a frame or receiver, or it could be converted into a frame or receiver. What does engaged in business mean? What is a bump stock, etc., etc.? Now, let's turn to the evidence of what I mean. Has the Supreme Court indicated contemporaneous evidence, meaning contemporaneously between the enactment of the statute that gives the power of an agency such as the ATF to act and the ATF or the regulatory agency's initial conduct as to how they thought that statute was supposed to work? That contemporaneous information, that contemporaneous actions by the agency is considered to be the best evidence in many aspects. And certainly some subsequent change will certainly be viewed as no can do by the Supreme Court. Let me just give you some of the language from Loper Bright. So you don't have to believe me. You can see what the Supreme Court itself has said about these issues. Let's start out with this phrase for this paragraph from the Supreme Court's decision in Loper Bright. The court has also recognized from the outset, though, that exercise an independent judgment often included according due respect to executive branch interpretations of federal statutes. For example, in the Edwards-Lessee versus Darby case in 1827, the Supreme Court explained that in the construction of a doubtful and ambiguous law, listen carefully, the contemporaneous construction the contemporaneous construction of those who were called upon to act under the law and were appointed to carry out its provisions into effect is entitled to very great respect. So you see what that language says? That where the law is ambiguous or there's questions about it, the contemporaneous construction of those who were called upon to enforce the law, meaning the regulators, the bureaucrats who are called upon to enforce that federal statute, their understanding and interpretation at the time, contemporaneously with the enactment of the statute, is entitled to some very great respect. That doesn't mean that they ultimately win. It means that that presumptively is something to be taken very seriously, in contrast to subsequent decades after the fact changes to a new interpretation, which is going to look a whole lot like some brand new made up, pulled out of thin air kind of understanding of the law, which is basically, I think, what the Supreme Court viewed the bump stock situation. And I think that's where they're going to go with these frames and receivers, the ghost gun issues, and so on and so on. But let me carry on. What else did the Supreme Court say in Loper Bright, in the majority opinion, that speaks to this notion that contemporaneous actions by regulators at the time the statute was enacted is particularly powerful, and this is terrible for the Biden administration, who does the absolute opposite, where they're trying to change all these long-standing interpretations because they're trying to reinterpret laws so they can basically make new laws through reinterpretation. Let's see what else the Supreme Court says. Such respect was thought especially warranted when an executive branch interpretation was issued roughly contemporaneously, that key word, was issued roughly contemporaneously with enactment of the statute and remained consistent over time. That is because the long-standing practice of the government, like any other interpretive aid, can inform a court's determination of what the law is. Again, this is the Supreme Court saying that if you have like an initial understanding of the law, there's an initial understanding of what a frame or receiver is, and then that doesn't change for decades, and then out of the blue, the Biden administration comes along and changes all this, that is not anything that's being done by Joe Biden that's contemporaneous, that's roughly contemporaneously with the enactment of the Gun Control Act of 1968, or the contemporaneously with the enactment of the National Firearms Act in the 1930s. So the Supreme Court is clearly indicating that if you play these games like the Biden administration has been doing with student loans forgiveness, with the ATF and so on, they're not going to like it. They're going to look askance at what the Biden administration is doing. But let's carry on and see what else the Supreme Court says about this notion of the initial understanding contemporaneously with the enactment of a relevant statute is particularly compelling evidence of what that statute means and why subsequent changes are really in a no-go, not allowed zone. The Administrative Procedural Act, in short, incorporates the traditional understanding of the judicial function, under which courts must exercise independent judgment in determining the meaning of statutory provisions. In exercising such judgment, though, courts may, as they have from the start, seek aid from the interpretations of those responsible for implementing particular statutes. Such interpretations constitute a body of experience and informed judgment to which courts and litigants may properly resort for guidance consistent with the APA. However, and this is key, interpretations issued contemporaneously with the statute at issue and which have remained consistent over time may be especially useful in determining the statute's meaning. Again, the Supreme Court is saying repeatedly in this Loper Bright case that if you ATF have interpreted what is a frame or receiver, what is a AR-style pistol, what is a bump stock, what is engaged in business, and so on, initially, in one particular way, in one particular manner, relatively contemporaneous with the enactment of the statute that you're trying to interpret to figure out the regulations on or about, and then down the road you change it, the Supreme Court is basically saying we will look at your initial understanding, your contemporaneous conduct, your contemporaneous interpretations contemporaneous with the enactment of the statute from which you're drawing your authority. But if you start decades after the fact making up stuff that's inconsistent and that is not contemporaneous with the enactment of the statute that you're to be drawing your regulations down from or interpreting to create your regulations, we're simply going to say, no can do, you ATF bozos. Okay? That is not what I'm saying. This is what the Supreme Court is indicating, where they repeatedly say in Loper Bright that, yeah, if it's contemporaneous information, contemporaneous conduct by the regulators under the statute they've been blessed upon or under the statute they're supposed to operate and enforce, well, that's important, but subsequent to that, not entitled to any difference. It's probably going to be evidence that's made up and no good, which is exactly what the Supreme Court basically said in the Bumstock case. Among other things, they're like, look, the ATF simply changed course. That's absurd. And they didn't like that. There was other arguments, of course, as to why we won the Bumstock case, the Cargill versus Garland case, but certainly they didn't like the fact that there was this 180-degree change in the interpretation by the ATF of what a bump stock was and whether or not it constituted a machine gun under the National Firearms Act. So anyway, there's other examples of the Supreme Court in this, including the Justice Neil Gorsuch concurrence that speaks also this issue of how to defer if you're a court, if at all, or not really defer, but really if you're a court, what to look at for evidence about what potentially a ambiguous statute might mean, and to specifically to look at actions that occurred at and around the time the statute was enacted as possibly giving you guidance as to what everyone understood that statute to mean. But again, when you're doing what the Biden administration ATF is doing and redefining everything, I think that this language from the U.S. Supreme Court in Loper Bright indicates that those ATF games under the Biden administration, it doesn't look good for them. They ought to get spanked, and they should get spanked. But given this Loper Bright decision, I think the odds of them getting spanked and the ATF getting terribly spanked by the Supreme Court and by the lower courts has increased dramatically. And it was already quite high. Now I think it's extra high given the language I just read to you as to what the court thinks is important, because I can tell you that the one thing about the Biden administration is nothing they're doing with the ATF is anywhere close to being interpretations or conduct that's contemporaneous with the enactment of the relevant statutes that they're trying to foist upon us in various ways in the form of gun control. All right, folks, hope this was not too geeky. Hope you subscribe to this channel. Make sure you follow me on X for more Second Amendment information at 4 Boxes Diner. And we will see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.